To this story now, the Helen Suzman Foundation has won a court application to interdict Home Affairs Minister Dr. Motsoaledi and his department from arresting, deporting and detaining anyone who doesn't have a valid Zimbabwean Exemption Permit. This pending the outcomes of the second part of the argument. Government extended the validity of the ZEP to December this year. Now the Foundation's Nicole Fritz joins us now for more. Nicole, thank you very much for your time here on eNCA. Just firstly, your reaction. It's been since April after the court reserved judgment, and finally today you get to find out that at least on this part of your fight against the ZEP decision, you've won this part at least.
So if I can just make a correction. I mean, it is true that there has been interdict granted, and that has been granted in respect of the Zimbabwe Immigration Federation matter. And part B of that matter is still to be heard. But we also got judgment today in the Helen Suzman Foundation and the Consortium of Refugee and Migrants application, where we had challenged the minister's termination of the Zimbabwe exemption permits on the basis that no fair procedure had been followed, no consultation offered, and no rational reason provided for the termination. And the judgment delivered today upholds our challenge and sets aside the minister's termination, holding it to be invalid and unconstitutional on the basis that it was irrational and that no fair procedure was followed.
So part B of the argument, which is expected to still be heard with regards to ending the ZEP to start with, still needs to go ahead in court. How does this possibly affect part B? I'm not sure.
So we, Zimbabwe Immigration Federation, and I think that they're...
We had lost you there for a few moments, Nicole. You had frozen, but you can go right ahead and answer the question. Sorry about that.
No, just to say that we're not the part, but Part B, as we understood, would seek significantly substantial relief to the relief that we won today in our application, which concerns no Part A or Part B, essentially to have the minister's decision to terminate the Zimbabwe held to be unlawful. And that is essentially that was the Part B application, but they in their Part A they've won the interdict. But as I said, I'm happy to talk about the judgment that was delivered today in favor of the Helen Suzman and the consortium, which essentially holds that the minister's decision to terminate the Zimbabwe exemption permit is irrational and valid and accordingly unconstitutional.
Now, in terms of the extension to December for Zimbabwean nationals to apply for visas, etc., does that at all, does today's judgment at all affect that? What would you advise, for instance, ZEP holders? Should they still go ahead and apply for visas, etc., just in case just in case maybe there's more court cases that will then rule against or for government?
You know, obviously, any Zimbabwe exemption permit holder who believes themselves eligible for a visa or for a waiver should be looking to exercise those options. But this judgment that was handed down today does not affect the extension. The extension till December still stands. So they are here perfectly legally. And the consequence of the judgment that was won by HSF and by COMSA is that the initial decision made in 2021 to terminate the ZEPs has been set aside and been remitted to the minister for a fresh decision. And so these processes are going to run concurrently. But for the moment, Zimbabwe exemption permit holders are here in the country perfectly legally. That is in accordance with the minister's extension. But in addition, because of the significance, the impact of today's ruling, the matter is to be remitted to the minister for a fresh decision. He will need to engage in a fair process. He will need to consult with the Zimbabwe Exemption Permit holders and with civil society and with the public at large before making a decision. And so that we will be notified as to how those timelines will run. Of course, and we will have to hear from the minister's spokespeople once they've had the opportunity to consider the decision. They may decide that they believe that they can challenge this decision. The interdict that was handed down today means that, in fact, there can be no deportations.
Yes.
So yes, there will need to be clarity from the department as to what is going to happen sort of from here. But as I said, people on the Zimbabwe Exemption Permit are here perfectly legally, and we will wait to hear from the minister and the department as to how they intend proceeding.
Just lastly, Nicole, and I'm hoping we can hear you because you do keep freezing here and there. I know that you said you're not necessarily part of the argument in terms of Part A and B of this entire court case, but what are you hoping as the Helen Suzman Foundation, a foundation that has been, trying to make sure that government is not seen to take decisions that are xenophobic, etc., or discriminative against other people within the continent or other people living here? When Part B does continue, what would the Helen Suzman Foundation be hoping the court does or decides in that particular part?
So I just want to try and make clear, because I think we're speaking at cross purposes. The HSF has been involved in litigation, but it was a separate application from the Zimbabwe Immigration Federation. And there have been two judgments that have been handed down today. I think that's what's creating confusion. So our judgment is one which the one which was handed down in favor of the HSF and COMSA today is similar to the Part B application that the Zimbabwe Immigration Federation wants, which is challenging the validity of the minister's decision to terminate the Zimbabwe exemption permits. They came to court at different dates. I'm not sure that, given the decision that we've had today, which is that the minister's decision is essentially rendered invalid, it's set aside, it's of no legal consequence, and he has to make the decision afresh. I'm not sure what happens in respect of Part B if the Zimbabwe Immigration Federation proceeds with Part B, given that the relief that we've obtained today in the Helen Suzman Foundation is essentially what they sought in Part B. But they also got the interdict, right? Which means that even if the minister decides to challenge or to seek to appeal our decision, that interdict stands, and that no Zimbabwean no Zimbabwean exemption permit holder can be deported, evicted, deported from this country.
And that they should be allowed to get in and out of South Africa with those permits. Thank you so much for speaking to us, Nicole. Fritz from the Helen Suzman Foundation.